Chapter 3 Law on Obligation and Contracts. Learning objectives: to identify the different kinds of obligations and contracts, to enumerate the ways of extinguishing an obligation, and to enumerate possible application of contracts in the tourism, travel, and hospitality industry. The topic outline: the law, discussion of the law, application of the law, and case study, and contracts, characteristic and classifications. The ethical basis of business is integrity, an ethical aspect that unites both private morality and public and professional ethics. By Donch Lee, Colorado Technical University. The law: a person desiring to engage in a business in the tourism, travel, and hospitality industry will meet certain obligations. Agreements arising from contracts will have to be made, and potential breach from these agreements will be encountered. Therefore, there is a need to study the fundamental principles involving the law on obligation and contracts. Obligations. According to Article 1156, an obligation is a juridical necessity to give, to do, or not to do. An obligation is a legal duty, however created, the violation of which may become the basis of an action of law. Every obligation has four definite elements, without which no obligation can exist, to wit. Number 1. An active subject, also known as the obligee or creditor, who has the power to demand the prestation. Number 2. A passive subject, also known as the debtor, who is bound to perform the presentation. Number 3. An object or the prestation, which is an object or undertaking to give, to do, or not to do. Number 4. The juridical or legal tie, the vinculum which binds the contracting parties. The juridical tie or vinculum is based on the sources of obligation arising from either the law or contract. It is important to identify the presentation in a certain obligation. Once the presentation is identified, you can determine who the passive subject is, whom the active subject can demand fulfillment of the obligation. The following are the obligation of the passive subject in: A. Obligation to give a determinate thing. Number 1. To deliver the thing which he has obligated himself to give. Number 2. To take care of the thing within the proper diligence of a good father of a family. Number 3. To deliver all its accessories and accessions. Number 4. To pay damages in case of breach of obligations. B. Obligations to do. Number 1. If the debtor fails to do what he is obliged to do, it will be done at his expense. Number 2. If the work is done in contravention of the tenor of the obligation, it will be redone at debtor expense. Number 3. If the work is poorly done, it will be redone at debtor expense. The source of liability for damages of a party in an obligation are as follows. Number 1. Fraud. The fraud is incidental fraud, for the term dolo incidenti, which is fraud incident to the performance of an obligation. In fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. Number 2. Negligence. The negligence referred here in the case of contracts, for example, common carrier, is culpa contractual, the lack of diligence or carelessness. Negligence consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, or the time, and of the place. There are two sources of obligation, namely, number 1, the law, and number 2 is the contracts. A contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Quasi-contract refers to a lawful, voluntary, and an unilateral act based on the maxim that no one shall unjustly enrich himself at the expense of another. The two common forms of quasi-contract are number 1, solutio indebiti, which is a payment by mistake, and 2 is negotiorium gestio, which take place when a person without the consent of the owner assumes the management of an abandoned business. Civil obligations arising from criminal offenses are governed. Number 1, by the provisions of the revised penal code. Example: restitution, reparation of the damages caused, indemnification of consequential damages. Number 2, by the provision of the civil code on damages. Example is moral, exemplary, and nominal damages. Quasi-delect, also called culpa aquiliana, is any act or omission which causes damage to another, there being fault or negligence, and there being no pre-existing contractual relationship between the parties. And the application of the law. Here are the case. Annabelle was crossing the street coming from the hotel to the nearby shopping mall. She was accidentally hit by a hotel car driven by Leandro, a driver employed by the hotel. Can Annabelle sue the driver, or can she sue the hotel? So here's the legal opinion. And yes, Annabelle may sue the driver and the hotel for damages on the ground of the culpa aquiliana. The pedestrian may also sue the driver and the owner of the hotel for damages for reckless imprudence arising from the crime under the revised penal code. The law. Classification of obligation. Number 1 is the primary classification of obligations under the civil code. A. Pure and conditional obligation, Article 1179 to 1192. B. Obligation with a period, Article 1193 to 1198. C. Alternative 1199 to 1205, and the facultative obligation, Article 1206. Letter D. Joint and solidary obligation, Article 1207 to 1222. A. Divisible and indivisible obligation, Article 1123 to 1125, and lastly is the obligation with a penal clause, Article 1226 to 1230. And this number 2, secondary classification of obligation under the civil code. A. An unilateral and bilateral obligation, Article 1169 to 1191. B. Real and personal obligation, Article 1161 to 1168. C. Civil and natural obligation, Article 1423. And D. Legal, conventional, and penal obligation, Article 1157, 1159, and 1161. Modes of extinguishing obligation, Article 1231. Obligation are extinguished. Number 1, by payment or performance. Number 2, by the loss of the thing due. Number 3, by the condonation or remission of the debt. Number 4, by the confusion or merger of the rights of the creditor and debtor. Number 5, by compensation. And 6 is by novation. Other causes of extinguishment of obligation, such as annulment, rescission, fulfillment of a resolutory condition, and prescription, are governed elsewhere in this code 1156A. Contracts. The law. Article 1305. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. 1254A. Discussion of the law. The essential elements of the contract are as follows. A. Consent, which is manifested by the meeting of the minds of the offer and the acceptance upon the thing and the cause which are to constitute the contract. The offer must be certain and the acceptance absolute. B. Object certain, which is the subject matter of the contract, and C is the cause of obligation which is established. Characteristic of a contract. Number 1. Mutuality of contract. Its validity and performance cannot be left to the will of only one of the parties. Number 2. Autonomy of contracts. Parties are free to stipulate terms and provision in a contract, as long as these terms or provision are not contrary to law, morals, good customs, public order, and public policy. Number 3. Relativity of contracts. Contracts are binding only upon the parties and their success or interest. Exception. Stipulation in favor of a third person. Stipulation for a tree, as in a beneficiary of an insurance policy. Number 4. Consensuality of contracts. Contracts are perfect by mere consent, and no form is prescribed by law for their validity. Exemption. A. Real contracts such as pledge, chattel, mortgage. B. Contracts covered under the statute of frauds. Number 5. Obligatory force of contracts. By the obligatory force of contracts, it constitutes the law as between the parties who are compelled to perform under the threat of being sued in the courts of law. Classification of contracts. Number 1. According to their relation to other contracts. A. Preparatory, or those which have for their object to establishment of a condition in law which is necessary as the preliminary steps towards the celebration of another subsequent contract. Examples are partnership, agency, common carrier, and insurance. B. Principal, or those which can subsist independently from other contracts and whose purpose can be fulfilled by themselves. Example are sales, lease, common carrier, and insurance. C. Accessory, or those which can exist only as a consequence of or in relation with another prior contract. Examples are pledge and mortgage. Number 2. According to their perfections. A. Consensual, or those which are perfected by the mere agreement of the parties. Examples are sales and lease. B. Or those which require not only the consent of the parties for their perfection, but also the delivery for the object by one party to the other. Examples are commandatum, deposit, and pledge. Number 3. According to their form. A. Common or informal, those which require no particular form. Example is loan. B. Special or formal, or those which require some particular form. Example is donation and chattel mortgage. Number 4. According to their purpose. A. Transfer of ownership. Example is sale. B. Conveyance of use. Example is comodatum. C. Rendition of service. Example is agency, lease of service, and labor. Number 5. According to their subject matter. A. Things. Example sales, deposit, and pledge. B. Services. Example are agency, lease of services, and labor. 6. According to the nature of the vinculum which they produce. A. Unilateral, or those which give rise to an obligation for only one of the parties. Example are comodatum and gratuitous deposit. B is bilateral, or those which give rise to reciprocal obligation for both parties. Example are sales and lease. According to their cause. Onerous, or those in which each of the parties aspires to procure for himself a benefit through the giving of an equivalent or compensation. Example is sales and insurance and common carrier. B. Gratuitous, or those in which one of the parties propose to give to the other a benefit without any equivalent or compensation. Example is comodatum. Number 8. According to the risk involved. A. Commutative, or those where each of the parties acquires equivalent of his prestation and such equivalent is pecuniarily appreciable and already determined from the moment of the celebration of the contract. Example is lease. B. Aleatory, or those where each of the parties has to his account the acquisition of an equivalent of his prestation, but such equivalent, although pecuniarily appreciable, is not yet determined at the moment of the celebration of the contract, since it depends upon the happening of the uncertain event, thus charging the parties which the risk of loss or gain. Example is insurance. Number 9. According to their names or norms regulating them. A. Nominate, or those which have their own individuality and are regulated by special provision of law. Example are sale, lease, common carrier, insurance, deposit, and agency. B. Innominate, or those which lack individuality and are not regulated by special provision of law. And that's all for the chapter 3, and thank you for your time to listen.